Fireaway tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fireaway is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
Welcome to episode 90 of Fire Away. I have to say I'm particularly excited about this. We're going to explore some of the intersections between the world of employment law and the world of criminal law. Little known fact about me is that when I was probably about 14, I decided I wanted to be a lawyer. So I was one of those strange people who knew early on what I wanted to do. But I actually assumed and expected and really wanted to be a criminal lawyer. And that took me all the way through law school. And for those listeners who remember the TV show LA Law, that was my main inspiration. And I assumed I'd be arguing, I would be arguing cases with employees with clients on death row. And then I found out we didn't have capital punishment in Canada. But despite that, I still wanted to be a criminal lawyer. Somewhere along the way, my path diverted to employment law, which is probably better for everyone. But I've got two real life criminal lawyers with me. So first of all, I'm very excited to introduce Mitch Worsoff. I have known Mitch probably about 40 years. We first met, not surprisingly, in a hockey rink. But Mitch is one of the top criminal lawyers in Ontario. He's got his own boutique firm with 5 associates, a number of staff and students, and practices across Ontario and has been practicing since 1997. So Mitch, thank you so much for joining me today.
Yeah, thanks for having me.
And Mitch was also very kind to introduce me to Henry Poon. Henry Poon is a Crown attorney in Toronto, has been a Crown for about 30 years, and this might be his last act as a Crown attorney because he's actually just about to retire. But he brings 30 years of experience as a Crown attorney. So Henry, thank you for joining me, especially as you get ready to end your career.
Nice meeting you, Stuart. Thank you for having me, and thank you for Mitchell for thinking of me. But I'm happy to be here to have a chat with you guys.
Thank you both. I think it should be a really interesting conversation. So I'll get right into that chat. And I was thinking about scenarios in which we have that intersection between employment law, which is my world, and criminal law, which is your world. And a couple came up to my mind, which come up quite a lot in my world. So I'll give you the first one. The first one is where an employer finds out that one of their employees has been arrested. And, sometimes it's, a small community, small organization. They've only got 4 or 5 employees, and someone is very publicly arrested. Perhaps it's for some conduct that's particularly offensive or scandalous. And you've now got this small business owner who is really worried about the impact on their reputation and what should they do. And the question that I get is, can we fire them? So I'm not going to ask you for your opinion on that because that's my purview. But what I'm hoping you guys can explain is, what does that mean when someone is arrested and charged, and what does the process look like after that point? So I don't know, Henry, if you want to go first, maybe you can explain what that means. And just by way of one last point, the reason I want to do this is because a lot of people assume that charged means convicted or guilty. And I'd like you to explain what it really means and what happens after they're charged.
So yeah, I think it's very important to distinguish the words, arrested, charged, guilty, found guilty, convicted. Those are all different things and have different meaning. But typically, from the Crown Attorney's perspective, once the file hits my desk, it means that this particular accused or employee has been arrested by the police, and has been charged by the police with what have you, theft over $5,000 or theft under $5,000 or fraud over $5,000 or fraud under $5,000. They are either released at the police station after being arrested, or they're being held for bail. And Mitch can probably talk more about that. But by the time I get involved, there's a sort of a prepared file for my consideration. the synopsis, like a document that tells me what the allegations are in terms of this employee and this accused vis-a-vis his or her workplace. And so at that point, they're arrested, they've been charged. Okay. They haven't, guilt has not been considered, had not been adjudicated upon, and certainly not been convicted. Okay. So they're assumed by our Charter of Rights to be innocent until proven guilty. But they are subject to bail conditions because they've been arrested and charged by the police. So that's when I, participate in the process, and it's sort of the first step in the road towards this either long or short prosecution, towards a trial or towards a resolution or settlement, as to what you might refer to in your world. So that's typically what where I get involved.
Got it. That's helpful, Henry. Thank you. And maybe Mitch, I'll turn this over to you. So, because I guess one of the questions, and I realize that every case is different, but what would happen next, and how long does the process typically take?
So just so Henry and I can speak about this for hours. So just so it's clear, the arrest is essentially a detention. The police have the right to stop you. They've got the grounds to stop you and investigate something. Like Henry was saying, it doesn't mean that you're charged. You haven't been charged with a criminal offense where you're facing court, where you may be found guilty. There's an investigation stage, and you're stopped. Once if you do get charged, then paperwork is generated. The police then become witnesses. They're not in charge of the case. Mr. Poon, before he was in charge of the case, is the Crown Attorney. Now, a few things can happen. When you're charged with a criminal offense, no matter what it is, you can be released from wherever you are. You can be released from the roadside of your vehicle. You can be brought back to the station. They can have you sign an undertaking or a promise to appear in court, or they can hold you for a bail hearing. And the police have 24 hours to present you before a justice. That's the rule in the criminal code. No matter what happens, either you're released or you're brought before a justice within 24 hours, where you're given the chance to be released.
Okay.
There's exceptions, of course. The Crown can put the matter off a day or two, up to 3 days, for further investigation, depending on what the charge is. But you've got to be presented before a judge or justice within 24 hours.
Okay.
If you're held for a bail hearing, depending on the severity of the charges, or if you have a criminal record, outstanding charges, whatever it is, it's up to the discretion of the Crown Attorney. They may say, well, we want to detain your client and hold him or her up until trial, and therefore you've got to then fight to get out of jail prior to trial at a bail hearing. So when a client comes to the office, either he or she has been released on an undertaking or a summons of some sort, an appearance notice, or somebody else comes to the office and says, my sister, my father, my cousin, my friend's in jail, and I want to get him out. He's up for bail tomorrow morning. When that's the case, I then contact the powers that be. I contact either the police or I contact the Crown Attorney, such as Henry before you, and say, well, do you have some information on this person? Can you send me something? He then sends me the synopsis that he spoke of, where I've got a decent idea of what the charge is about. I then try to negotiate with him if we can work out a release with some reasonable conditions, whatever the Crown Attorney thinks is reasonable. Or he may say, and Henry's done this a few times, he said yes to me and he said no to me over the years. I've known him for approximately 27 years now, 27, 28 years. And if he says, no, I'm not going to release your client, I then have to try to get someone who's going to sign for the person in jail, called a surety, like a guarantor,
Right.
where they can say, yes, I can watch over that person while they're out of jail up and, pending trial, and I'll make sure that they abide by the court conditions that are imposed upon him or her. They become the jailer. They can also revoke their suretyship. They can revoke the bail for any reason they want. They don't have to have a reason. And the person then goes back into jail. So those are the modes of release. Either you're released from where you are, or you can be given an appearance notice at a later point, or you're held for bail.
And so, as you said, whether you're stuck in jail or whether you've been released, at some point there's going to be a conclusion, which I am assuming is either a judgment or some sort of resolution. So maybe you can take me through how that typically plays out.
Well, as I was saying, it's within the discretion of the crown attorney who's assigned to the matter for bail. The crown attorney who looks at the bail isn't necessarily the one who runs the case up until its completion. It's not that linear, but you'll have a crown who's in charge of looking at the files to establish if the person is eligible for release. If they are, it can be worked out with the person's private lawyer or maybe a duty counsel who works in the courts for unrepresented accused people. And then they're released, or a bail hearing is had, and a justice, that is a provincial court judge or a justice of the peace, will decide if they're eligible for release.
And so, I'm fast forwarding a bit, but how do we get to the ultimate conclusion, which is either some sort of judgment or some sort of resolution? How long does that usually take?
Well, it could take weeks. It could take 45 minutes. It depends if the crown's going to consent to the person's release, or if the crown determines that the person should be detained. Then there's a hearing between the lawyer and the crown, and a justice decides if the person's able to be released. And they consider certain things within the criminal code if the person can be released on bail.
Right. So maybe I'll switch back over to you,
that's
Henry.
just the first step. I think we're talking about. We're talking about the bail.
Yeah. Thanks, Henry. I want to fast forward a bit to the last step.
You want to get right to the very end. So
yeah,
it really depends on the nature of the allegation, right? So let's say the employee is charged with theft or fraud over $5,000. And let's say the amount that's being alleged is that he's been embezzling over the years, and the total loss is alleged to be in the millions of dollars. Okay, so that's in our world, that's a big fraud case, but it's still a white collar case as opposed to like a case involving guns or violence or sex assault or what have you. But in a big sort of fraud case like that, you might expect that there would be a trial, because in a allegation that involves millions of dollars of loss, long jail times in the mix.
right.
Certainly, the norm is jail time, potentially penitentiary time, which is 2 years or more in a Kingston penitentiary. Okay, so a lot is at stake on a charge like that. So a guy like Mitch would probably have multiple discussions with the Crown Attorney, and thereafter a judge, to set up, issues for trial and to schedule a trial date. And if the matter has to go to trial, it might take weeks. And for something like that, from beginning, from arrest to the trial, whether it be in front of a jury or a judge alone, could take up to years. It could be 2 years, 3 years before we ever get to that point. Okay.
Yeah.
But I think a lot of cases, much like in the civil world, but not as much as the civil world, a lot of cases resolve before they actually get to trial. Okay. So if, for example, Mitch works out a deal with me to say, okay, he'll pay back X amount of millions. He should get, instead of 4 years in jail, we want to keep him in the provincial jail system, and let's say, give him a year or a year and a half in jail. That's something that someone like Mitch and I would discuss over a period of time to see if we can resolve the case. And that could take anywhere from weeks to all the way up to the years before the trial, just like in the civil world, right? So you're just sort of angling towards and getting the most leverage you can before the resolution.
Yeah, that's helpful. And I know the latest statistics I've heard is that in the civil courts, less than 1% of claims filed actually make it to trial. I don't know if you have an idea of what that would be in the criminal world.
Well, I mean, I've been a Crown for 30 years, although I article with a civil firm, an insurance litigation firm. And yeah, and I can, you can vouch for that. Almost everything settles in the civil world.
Yeah.
In the criminal world, almost everything settles as well when you take into consideration all the cases, all the charges that are filed by the police, right? But there are still a lot more cases that go to trial in the criminal world than the civil world. But in criminal, I would say about 80 to 85%, and maybe Mitch can chime in here. I would say 85 to 90% of the cases will resolve without a trial.
I've heard it's more. I heard it's closer to 95, but
Wow.
maybe
Yeah, that could be. Yeah, that
Yeah.
could be.
Yeah. So I want to pick up on, Henry, you've sort of been talking about this scenario where, if someone's accused of theft or fraud, basically taking money from their employer. So that's my second most common scenario. So now it's not just that the company found out their employee was arrested. It's the company believes or suspects that one of their employees is stealing from them. And obviously we could be talking about a cashier who's taking, $20 out of the till, or we could be talking about the CFO taking tens of millions of dollars. One of the questions I often get, though, from clients is, well, should we call the cops? Should we have this guy charged? And one of the things that often comes up, and you guys,
Sorry, your client would be the employer?
Our client would be the employer.
Yeah, okay.
So the question we often get, or one of the things I often try to assess is, will the police or the Crown even be interested in this? Or do they see this as sort of a civil dispute? And I know it's hard to talk about that in the abstract, but I was hoping you might have some thoughts on that.
Well, yeah, no, I mean, anytime where someone is alleged to have stolen from their employer, the courts are supposed to take it very seriously. It's called a breach of trust because you're entrusted and you're hired by your employer to do a certain duty, and you breach that trust, right? And you're in a unique position to be able to have access to that till. You're not just some guy off the street, right? So the courts are supposed to take it seriously. In fact, that the courts have said that any breach of trust fraud involving an employee stealing from an employer should attract a jail time. Should attract jail time, period, no matter whether the person has a criminal record or his or her circumstances. I mean, that's what the courts say, but fortunately or unfortunately, Mitch can tell you that mostly never holds. If the dollar amount is small, if there's repayment, I can tell you, and Mitch can chime in as well, there's seldom ever any jail time. But you should, as an employer who's been victimized in this situation, you should always call the police.
Mitch, any thoughts on that?
Our court system is very overtaxed, and there are so many charges being laid every day. Theft is a very common one, unfortunately, and people are getting arrested for all kinds of thefts, for all kinds of small amounts as well. And most often I find, and I've been a lawyer now for 28 years, and I find that a lot of the theft cases that I'm faced with simply go away with repayment or forms of diversion of some sort, because the Crowns are so simply overtaxed with bigger cases they have to prosecute, and there's a finite amount of time and resources. So it's funny because I've got clients who tell me that in other countries, if you steal something, you're punished severely. Some countries you're physically punished.
Yeah.
Some countries, I think over in the Middle East, you get your hand cut off publicly. They describe how you can drive downtown to a main city in one of these countries, and you can leave stacks of money in an open car, in a convertible, and nobody will touch it. Here, I've had clients who steal, even from employers, 5-6 times and never see jail, depending on circumstances. So it's different societal views, values. But there's a difference, certainly, as Henry was saying, between someone who walks into a store and steals an item, and then someone who actually works for the store and steals an item, because there's a built-in trust. The employees are expected to be trusted and to be loyal to their employer, so that the prosecutors and judges do take those cases more seriously, as they should, I guess. Not that any theft is acceptable, but a lot of those cases I find, especially for lower amounts, are not prosecuted. People are given the chance to make restitution.
Got it. Yeah, that helps, Mitch. I think that makes sense, and that's consistent with what I've seen as well. And but I think sometimes a lot of employers are disappointed by that or surprised by that. But I think it's important to give them the reality. Now, one thing I wanted to mention, because this comes up a lot too. Sometimes what will happen is I'll be contacted by the employer, and they'll say, we believe that so and so is stealing from us. We want to fire them, and so I'll take them through the termination process. But then if the employee turns around and sues for wrongful dismissal, they want me to threaten to call the cops and file criminal charges. And this is one of those things that always stuck with me from law school, but I was hoping you guys could explain why it is not appropriate to threaten criminal charges in the context of a civil negotiation.
I believe there's a rule of ethics. Henry can correct me. I'm not sure a lawyer's allowed I mean a civilian can, of course. It's not a threat that's contrary to any law, but certainly the criminal code. But a lawyer cannot threaten criminal proceedings in a civil matter. I believe that's a rule we learned many years ago. Henry can tell me if I'm right. There's certainly an advantage to informing the authorities. You'll have I guess a leg up, if you will, on the employee,
Mm-hmm.
and it may be an easier termination, I guess, in your parlance, if there are criminal charges pending, if the police charge, and if the person was found guilty in some way. It just bolsters,
Right.
it just strengthens your case, right?
Yeah, but like you, I always had that understanding that you couldn't threaten later to file charges if you were negotiating. But Henry, I don't know if you have any more to add on that.
Yeah, no, you can't sort of you can't threaten others, for let's say bodily harm or threaten to harm them. But I think in the civil world, I mean, threatening legal action, uh, 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 the employer threatening legal action, I don't know if there's anything, the criminal law that can stop them from doing that. But I suppose the problem that is a crown that we run into is when you sort of mix the two worlds, the civil and the criminal world, it tends to muddy the waters in terms of the future credibility of any witnesses, right? When they're talking about the case. Because then you got the whole aura of motivation to lie because of potential financial gain, right? So from the Crown's perspective, we like to just have the two system uh, in two silos. Okay. What we like to see, ideally, from a prosecution standpoint, is as soon as you believe there's criminal misconduct on the part of, in this case, an employee, you should call the police. Because if you don't, a defense lawyer down the road may say, "Wow, you're really not victimized. You haven't really been victimized by any crime because you didn't even bother to call the police in the first place."
Right.
Right?
Yeah.
So that can be exploited by clever defense lawyers like Mitch. So you want to sort of, keep those two things in separate silos. That's what I like to see anyway,
Yeah.
because there's
Makes sense.
always an opening to attack, motive to lie and things of that nature.
Which reminds me, I had a case with Henry a few years back, and we had this individual who was involved in tumultuous family law proceedings, and he was trying to push the Crown Attorney's office in Toronto. I think Henry was in North York at that point, at 1000 Finch Court, to proceed on criminal proceedings. And Henry, I think, took the position that he was trying to get a leg up or a better angle for his family law proceedings. In
Yeah.
the end, the Crown Attorney's office discussed the matter and didn't proceed with the criminal proceedings because they were skeptical of this person's motivation.
Well, yeah. So that's a slight distortion, Mitch, but I'll correct it. Um, I think there was always, motivation based on the matrimonial proceedings in the background on the part of both parties in that case. But in that case, what was the determining factor was that he had called the police, okay, as a complainant of an assault or assault against their common child or what have you. And the police had investigated thoroughly, okay, and came to the conclusion that there was no criminal conduct, provable criminal conduct, no grounds to lay a charge. And and he was obviously very disappointed because he was wanting his wife charged, right? Because maybe he wanted to gain a leg up on the family dispute. And
Right.
so that's when he went to the courthouse to have a private information to personally lay a criminal charge against the wife.
Hmm.
And that's when I got involved. And so when I looked at the file and I looked at the matrimonial background, as well as what the police had investigated and they had found, I realized that, this was just, there was no hope of getting a conviction on this matter.
But to your point as well, I believe in that case that the wife he claims had assaulted him a few times, but he never called the police on her.
Yeah,
He
that's
didn't
right.
lay, he didn't lay he didn't want the charges to be laid, and so he suffered by that at a
Hmm.
later point.
Yeah, yeah. Yeah, so a timely complaint is always preferable.
Right.
Yeah. So picking up on that, because I take your advice, timely complaint. So what sometimes happens though, and I've seen this a few times, and I suspect you guys have as well. So imagine the employer thinks or is convinced that their employee is stealing from them. So they file the complaint with the police. They then end up firing the employee. There's some negotiations about severance. And as part of the negotiation, the employee's lawyer says, okay, and you'll agree to withdraw the charges. And I often have clients who say, oh, yeah, of course we'll do that. But I'd like you guys to explain. Maybe Henry, you can go first. My understanding is at that point that's out of the complainant's hands. They can't withdraw the charges because the crown attorney has
Yeah,
control of it. Is that right?
yeah, that's right. And that's a common misperception on the part of anyone that may feel that they've been victimized, that they can initiate the charge and they can drop it at any time they want. Okay, that's not the case. Once you've called the police and the police have investigated and they've determined that there are grounds to lay a charge, then that they lay a charge, then the case goes to the Crown for prosecution. Now, as a Crown, I take a complainant or victim's input very seriously, and I give it a lot of weight. Okay? But the ultimate decision whether or not to continue with the prosecution or drop a charge is the Crown's decision.
Right. Yeah.
So now, I mean, and I could segue into the world of domestic assault to cite an example. We have, I dare say most of the cases in our system are domestic related allegations. Okay. It's just a common problem.
Right.
And a lot of them involve a spouse who's been assaulted, usually, husband on wife. The wife, because, they've been assaulted, they feel frightened, they're in fear, legitimately, and they call the police to get the police to come arrest the husband or just to stop him, just to stop the fight so she doesn't get beat up anymore, doesn't get abused anymore, or yelled at anymore. Never expecting the police to lay a charge. But the police come, they see some bruising, they see her crying, they see disheveled clothing. They will charge, in most cases, the husband based on whatever the wife is saying. Okay? And so the matter gets to court, and very, very commonly, the spouse, the victim, the wife, will come sort of begging and crying for the Crown to drop the charge because now they're separated, they can't have contact, he's not supporting her, he's not helping her with the kids and the household duties. She needs him.
Right.
But depending on the severity of the allegation and the history of the couple, as a Crown, we will not simply drop the charge at her say so. We need to take into consideration other factors. So
Yeah.
it's the same way in an employment context, although it's less common that a victim will say, well, charge and
Right.
then not charge and then
Yeah.
drop.
But I think that's a really important point that you can't just file the charges and then drop them. It's not as simple as
No,
that.
it's not.
That's
It's
a really
not.
important
It's
point.
not within
Yeah.
your power to do that.
Perfect. So I think I say this every single episode, but the time flies by way quicker than I expect. So before we wrap things up, though, I always like to give our guests a chance to promote themselves and their practices. So, Mitch, if people want to get in touch with you, what's the best way to do that?
Well, I'm at 469 Lawrence Avenue West, and we're working 6 days a week, including Sundays. Or they can call at 416-423-3333, and someone's always here to answer the phone. So I thank you very much for the time.
Oh, Mitch, thank you so much for joining me and also for recommending Henry. And Henry, I'm not going to bother offering you a chance to promote yourself because you are just about to wind down your career. So I will thank you as well for joining me, and I wish you all the best in retirement. I really appreciate you doing this today.
Well, thank you very much.
Henry hasn't had a business. He hasn't had a business card in 30 years, so he's okay.
Yeah.
All right. Well, thank you guys both again. Now I will take my turn to fire away. So picture this. You're a small employer in a small, tight-knit community, and you find out that one of your employees was very recently and very publicly arrested, perhaps for something that's particularly offensive. You're worried about whether you can deal with the damage to your reputation and wondering if you can let them go. So can you fire them is the question we get all the time. And I expect that every single business owner watching this is hoping I'm going to say, yes, of course you can. But the reality is that the answer is what it typically is in the world of employment law. It depends. This is a question we talked about in episode 90 of Fireaway, but it comes up a lot, and I want to repeat this and revisit the issue. So I know that it depends is not the answer most people want, but as anyone who knows me is aware, I've spent far too much of my career, far too much of my life studying the topic of just cause for dismissal. In other words, when can someone be fired from their job? And I've even written a book on it. The book's called You're Fired. And one of the things I have learned is that there are no hard and fast rules. But it's clear the courts will always take a contextual approach, meaning they will look at all relevant factors: the nature of the person's job, how long they've been employed, have they been in trouble before, and how they respond when they are confronted, which leads to the second question we always get. Do you really have to give them a chance to explain? Here's the simple answer. Yes, you absolutely do. If you're even considering dismissal for cause, you need to confirm your suspicions and give the employee an opportunity to respond to them. And their reaction is often a critical factor in assessing whether you have just cause. Because remember, the test is whether the employment relationship has been irreparably harmed. I get a lot of pushback on this, and the most common response I get is something along the lines of, surely, if we catch someone stealing from us, we can fire them for cause. And the answer again is, it depends. Yes, if we're talking about your CFO, who has been clearly embezzling millions of dollars over years, you've got a very strong case for cause. But if you're talking about your receptionist, who took a pencil home at the end of the day so that their daughter could do their homework that night, technically that's theft. But I wish you good luck if you want to fire them based on that alone. So just cause is one of the most complicated areas of employment law. Courts take it very seriously because the consequences are so severe. They often refer to it as the capital punishment of employment law. So here's another intersection between employment law and criminal law. There's never, or almost never, an easy answer, but there's a very clear takeaway from this. Get legal advice before you act, because it almost always costs less to prevent the problem than it does to fix it. As we always say, if you think you might need an employment lawyer, you probably do. That's a wrap for episode 90 of Fire Away. If you enjoyed the episode, hit the subscribe button and also share it with your friends and your colleagues. We release a new episode every month, so you can find them anywhere that you find your podcasts. You can also follow us on social media, including my attempts to create some memorable TikTok videos. Sign up for our newsletter to keep up to date with all of the Canadian employment law updates. Thanks, everyone, for tuning in. Thank you to Mitch and to Henry again for joining me. And as always, Mark, thank you for producing. And the hockey season is over. Unfortunately, we still don't have a Canadian team as the Stanley Cup champions. But I'll sign off, as always, quoting one of my favorite hockey broadcasters. The pleasure was all ours.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok. liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.